Well, it was a good day yesterday, and we're hoping for another good one today. We've got a lot of good people lined up. I think we're opening this session with something pretty unusual, which is 3 lawyers here to talk to you. But litigation, unlike a lot of the pneumonias, litigation really is out there with Legionella, and I thought everybody should be aware of it. Planning committee agreed, and this morning, we have, like I said, 3 lawyers to share their insights as to how litigation concerns may need to be considered as we move forward with both research and policy. The 3 lawyers are Susan Smith, Dan Moretti. Susan Smith and Tom Bernier actually come from the same firm. These are all defense attorneys, but they know the plaintiff's side. Dan Moretti hails from New York, and I'm going to turn this over to Susan Smith right away. I will, before Susan starts, I want to mention that both Tom and Susan are very involved with legionellosis litigation. Dan Moretti is as well, but he actually does more with high-profile construction and environmental litigation broadly. So I thought it's a little bit different twist.
Good morning, and thank you for having us here. It's a great opportunity to be educated by really the best minds on this topic. Tom and I have been practicing together for about 7 years. We met on a Legionnaire's disease outbreak case in Baltimore about 7 years ago now. And since that time, we have seen pretty much every variety of Legionnaire's disease-related matter come across our desks. In the last couple of years, we've handled matters involving more than 40 individuals claiming to have contracted an illness associated with Legionella bacteria. We've handled matters in more than 12 states. We've had calls from corporate general counsel with the CDC coming to collect water samples from their building and looking for guidance on that. And we've handled wrongful death cases where people had contracted fatal cases of Legionnaire's disease. And the whole spectrum that comes from that, people who are claiming to have contracted Legionnaire's disease but truly have a food poisoning pathogen and no Legionella infection. So we've seen all varieties of that. We are definitely seeing an uptick in litigation associated with Legionnaire's disease. The planet, Tom, can I get the first click? Okay. What we deal with is cases involving, and because of our friends on the plaintiff's bar who do good work in their own way, who are really driving the surge in litigation. And they do certainly serve a social function in enforcing standards and so forth. So I won't knock them too much. But this is the reason why we've got the surge in litigation. Substantial awards and settlements that can be associated with these cases. The personal injury cases, some of these are product liability cases involving hot tub filters and different things that go wrong. But this is what the potential compensatory damages that are coming from these things are significant. So we've got people on the hunt looking for opportunities to monetize these risks. One of the emerging issues that we're dealing with a lot, and we've written a lot about, is what is the standard of care? So these are cases dealing with negligence. Negligence is the violation of a standard of care, that somebody was not reasonable in managing or maintaining their premises. In talking to all of you, we hear the standard of care with respect to managing water systems, and it defines what is reasonable conduct in managing those systems. And to date, when we first started working on this, a lot of the community that's dealing with these issues takes this approach. What's Legionnaire's disease? What's Legionella? This isn't a problem that we deal with. We don't know anything about this, and there's nothing that we're supposed to do.
Just one second, Susan, just before, just jumping into the standard of care. Those that looked at the prior slide about the numbers, the sort of numbers that are being rendered in either by juries or in settlements, that Legionnaire's disease is looked at very seriously. These patients, or in our cases, in lawyer jingo, are plaintiffs, are very, very sick and very compelling cases for judges and juries. And that's why you're going to see numbers that are in the millions of dollars for awards in these types of claims. Sorry.
No, we want to give you the perspective on this because the litigation world is foreign to the science world. And so to put this in real-world perspective, we've handled lawsuits against real estate developers, property management companies, the owners and operators of hotels and multifamily housing communities. We've been involved in litigation where the targeted defendants include the owners, site engineers, product manufacturers, architects, general contractors, those in the plumbing and mechanical and plumbing engineering trades, people who design these buildings, install hot water heating systems, and service contractors who work on those systems, water treatment companies, and municipal entities. So the whole range of targets here is significant. And the theory against these people is that they all should have done something to prevent the amplification of Legionella. They should have done something to prevent the colonization of their systems. They should have designed their products to prevent the dispersion of Legionella or the amplification of Legionella. And what we see repeatedly is this expectation foisted upon them by the plaintiff's bar saying, you should have done something, this is a preventable problem, you should know about this, and there are easy and expensive steps that you can take to mitigate those risks. But from their perspective, these product manufacturers, engineers, architects, designers, builders, and so forth, it's been a theme that we heard about a lot yesterday, was they're not executing their job from a public health perspective. These professionals are executing their job within their professional world, which is to design to plumbing code, design to building code, design to design parameters within the product's world. The owners and operators of facilities are making sure the lights are on, the water's comfortable, the guests are safe within the common understanding of safe. And so they're quite shocked to be on the receiving end of these lawsuits because they're not, microbial control is not on their list of day-to-day tasks. And so when the legal conversation turns to whether these people should be held legally liable in a court of law for causing a case of Legionnaire's disease because of their allegedly inadequate practices, they're just astounded because, again, that's not part of their core function. So the courts have struggled with what is the standard of care, what is the proper benchmark to measure their conduct against. To date, there have been, let's see, the standards of care are, the formal guidelines that define what is reasonable. And when we get to looking for the standard of care for Legionnaire's disease, you go to the law books where you might look for a statute, a rule, a regulation, and here you go, you've got nothing. It's just not there yet. What you do have is a very broad array of guidelines that have been published, and you all are familiar with these, and so we're going to touch upon these very briefly. Just when we go into court and a plaintiff's lawyer is attempting to demonstrate that there is a standard that defines the conduct that should have been implemented by the targeted defendant, they point to all of these documents. And there's many of them in many different contexts issued by many different organizations. And that's an important point because standard of care is about consensus. And when you have the whole variety of communities coming in from different aspects of the public health world, engineering, and so forth, it actually illustrates the point that there is no consensus on reasonable practices to prevent amplification and dispersion of Legionella. In the courts that have dealt with the issue, there are two opinions that have been published so far, have decided that this whole volume of guideline does not constitute a legally binding standard of care. Because of these issues, they're advisory in nature, they're not specific, they are not widely followed except in segments of the healthcare industry. There's questions about whether any specific guideline has been validated and tested and shown to be reliable at mitigating amplification. And then even the requirement of routine testing has been the subject of some debate. So there's nothing automatic about any of these things becoming a standard of care. In New Jersey, there was a case in 2013, and then a Maryland case back in 2007, where the court has examined them at length and said, there's no consensus here. So we don't have anything in the law books, we don't have anything in a guideline that represents a true consensus that a court will recognize as a standard of care. What we are seeing, though, is these targeted defendants, owner-operators and so forth, creating their own standard of care. There may be nothing in the law books, but another source of a legal standard of care is your own conduct. You're held, if you have a plan, if you have a procedure and protocol, you've created your own standard. And that's what we're doing with ASHRAE 188 and these water management plans. We have guidelines here that are potentially code adoptable. We know there's conversations happening in various corners of the building code and construction code industry to potentially adopt these into code where it's binding. But we also have people scrambling to get their water management plans together because of ASHRAE and the AIHA guidelines. And when institutions are acquiring or obtaining water management plans for their facilities, they are creating their own standard of care, and that they'll be held to.
Just to add,
Yeah.
the standard of care is obviously very critical here, but when you wind up in a courtroom and a judge decides that your case is not going to be dismissed, that you're going to be going to trial, juries are, in many states, are advised that landlords are charged with providing a safe place for their tenants and their occupants, and landlords are required to provide a safe environment for their office workers, and they frequently will be charged that they should take action for reasonable risks that they should have known about or that they knew about. We make efforts on behalf of defendants to dismiss cases. We follow the standard of care, but if those efforts are unsuccessful and you wind up in a courtroom with a jury, the charge that the judge can give to the jury can be pretty tough, and particularly in these cases that Susan and Tom and I have experienced over the years. As I said before, the Legionella disease patient is frequently someone who has been, seriously hurt and has some residual problems with them in terms of their injury and respiratory function, and those are very understandably very sympathetic plaintiffs. Sorry.
No, that's it's a good point. The battleground. I mean, people can often say that you're advocating for a position that these targeted defendants, property owner operators primarily, don't have to do anything to mitigate these risks. The bottom line that's fairly universal is that they do have to be reasonable in their conduct with respect to managing their premises or designing their product or designing a building and whatever the specialty may be. The debate here is what is reasonable and whether there is any specific guidance that they were obligated to comply with. But these are absolutely very dangerous cases. Another groundbreaking development in the last few years in terms of defining the reasonable steps property owners and operators need to take is that the New York City regulations. That is a true standard of care because it's a regulation that's in the law books. And Dan, being based in New York, can address the potential impact of that. But it's comprehensive and it's very aggressive in the compliance scheme. And that's certainly got the attention of people all over New York and elsewhere, because people who operate in New York, who are subject to these regulations, are now wondering, wait a minute, we operate in California. We know about this regulation. Are we going to get into trouble if we don't do this protocol out in California and all our other facilities? So it's gotten a lot of attention, and it certainly is driving a lot of activity towards, obviously, cooling tower management. It's got a lot of people very concerned about the consequences.
Just the New York law, which was touched on yesterday, is really an important step in preventing the occurrence of this disease, because it requires certain things that the folks from the city touched on yesterday: registering cooling towers, certifying cooling towers, testing them. And I think another important part of the law, which is interesting to me from a lawyer's point of view, is it really does require that the landlord be made aware of the findings that the tests are revealing and the maintenance that's taking place, number one. Number two is, again, very importantly, it makes the property owner certify certify what those findings were. So the New York law, in addition to testing and some other, what I'm understanding from this conference, does a lot of things, but from the lawyer's point of view, it really takes out a piece of a lot of cases that Tom and I and Susan defend, which is where a landlord will frequently say, this was the problem of the property manager. This was something that was supposed to be taken care of by my water treatment company. This law really says, well, that may be the case, but ultimately the buck stops with you, and you had to have been aware with it. If you were following the law, you would have to be certifying the quality of your cooling tower and its system. So I think it's a very interesting law. I'm very curious to see how it evolves and how the cases develop going forward.
And the important distinction with the New York regulations is the very specific protocol that it sets forth. It defines who it applies to. It defines who is responsible. It defines very clearly what they're expected to do, which is reasonable in managing a cooling tower. The problem with the other guidelines that have been rejected is the vagueness and breadth of them. And there's debate about who they apply to and whether it's mandatory that they take any action and so forth. But the New York regulations make it absolutely crystal clear who it applies to, what they're supposed to do, and it's transparent and has to be validated. And from the landlord standpoint, that's very, very dangerous. But from the public health standpoint, that's going to be a huge step forward. So I think this is going to be the first step in some significant changes nationally with regard to Legionella control. It's got some teeth, and it gives some very clear guidance. So now we're going to talk about a couple of the other issues that are on the horizon, and the dialogue yesterday has touched upon some of these. And in addition to the battleground of the standard of care and what owner-operators and product manufacturers and designer builders are supposed to do, we've got many other things that are coming up. What's the safe level?
Right. Yeah, the idea of maybe trying to predict what's going to happen legally going forward is always a guessing game in some respect, but I think what you're going to see now is that as far as the law is concerned, building owners are going to be expected to have a viable and documented water treatment plan for potable water, and I think, clearly for cooling towers. The question becomes, what is going to be the expectation that makes this reasonable? And we had the discussion all day yesterday. I mean, we are dealing with a bug that's ubiquitous. The attack rate's 5%. It comes in potentially on the municipal water that everybody assumes is always going to be, going to be safe. Are we moving, default-wise to a zero tolerance for this bug in building systems? We do asbestos and lead and mercury, and we see, the no safe level mantra beat us over the head, by plaintiffs' lawyers, and the courts seem to look at that. And, the question is that where we're going, with respect to Legionella in cooling towers? I mean, many of the water treatment professionals we deal with, seem to tell us that, you can do a lot, but zero is really, really unrealistic, especially with something like a cooling tower in a building down south.
And to put this in a legal perspective, and the grounding is the obligation on owners, operators, builders, managers, designers, et cetera, is to take reasonable steps to prevent against known hazards or latent hazardous conditions. The question here is, when does Legionella in your water become a hazardous condition against which you have to take some protective measures? And that's going to be the subject of a lot of debate, because there truly is no consensus. How many CFUs per mil do you need to have in order to trigger action when there's an actual health risk associated with that condition? And in the legal context, it comes down to foreseeable risks. And sometimes our position is going to have to be, this is an invisible, odorless, microscopic bacteria that exists in many water systems at non-detectable levels. It amplifies because of food and heat. Food and heat are necessary elements of any distribution system for water. We've heard from all of you that you can't have water running through pipes without having biofilm. And then it amplifies, there's questions about whether it's predictable or not when you're going to have an amplification. But in order to produce a case of human disease, you need to have amplification of a pathogenic form of the bacteria. There's 70 subgroups, you'll all correct me on this, 70 species, 50 subgroups, and only one of which is recognized as causing the majority of human cases of illness. Then it has to be aerosolized, inhaled into the deep part of the lung by a susceptible host, and infection take place, and then you may get a case of disease. And in that context, is it reasonable, with the somewhat remote risk of a human case of illness, is it reasonable for building owner operators to be held to adding secondary disinfection systems, to routinely test their water systems for Legionella, and take these other measures?
Right. I mean, lawyers like us, when we're defending clients, especially clients in tough spots, love the gray areas. I mean, it's where we live. Thank you for that. Judges love the bright, clear lines. It makes their lives very easy. So they're always looking for, give me the threshold, give me the standard, give me the checklist that I need to go down to see if someone legally met the standard of care. And we constantly, with things in OSHA for lead, or CDC levels for lead, or OSHA levels, PELs for asbestos, they're getting pretty exact on what they set out in these documents, and the lawyers glom onto that and they fight about these levels. Are you above them? Are you below? For Legionella, I mean, we haven't seen many. I mean, I think we all know these numbers from the OSHA document. I think they come from Brian's lab originally. These are numbers that we see often cited in terms of, depending on which side your CFU level is, we either like them or we don't. But that's a number that comes out. I think Texas had a 4 for their statute on the Garland County as to whether there should be some action taken. But it's not as fleshed out clearly, and I think we're going to hear speakers today talk about whether there is a safe level, and if so, is it a safe level? And we always hear dose response, but which would imply that maybe there's a dose below which people don't get it. But in this case, it's not maybe as clear as as asbestos or lead, which is, believe me, by no means clear in the legal setting. So in forefront in all of this debate, when you're talking about what building owners should be doing, is the issue of routine water testing. We know the new ASHRAE document suggests may not be necessary depending on what else you're doing. Dave Krause's new guideline out of the AIHA says that's the only way you can go ahead and validate a system and see if it's working. The VA is getting to the testing situation for validation. CDC says, hey, maybe we just wait and see if there's an outbreak and then decide how we test or follow up to get rid of it. New York code now is going to be, we want testing. So it seems to be moving, to be honestly, towards some kind of testing. But then from a legal point of view, we always have issues on that because, when we're we're advising someone who may not be in the soup yet with a litigation, they're asking us, what should we do to protect ourselves best? We do a lot of that kind of counseling. In fact, we prefer to do that kind of counseling in advance of somebody actually getting sued. They ask us, should we be testing? And there's some pros and cons to that. I mean, clearly, if you want to know if your system is generating Legionella bacteria and whether your system, procedures are working, well, why not test and see if that actually has Legionella in it? It makes kind of good sense. It helps you chart trends. Are we getting our spike the same month every year? Or is it an event that we throw or do, for a concert that we see a spike, before or after? Is it, in the winter? Is it in the spring? It also gives us a real good way of saying, hey, look what they were doing. They've established, a very reasonable situation here where they're doing the system work, and they're following it up with testing. How can you beat that? How can you tell anybody who's doing that they're not meeting the standard of care? And lost in all this is, the idea that people want to know they're protected. I mean, when you get to the insurance issues for Legionella, the general exclusions in many cases are being invoked to bar coverage. That got a little gray, and there was some back and forth on whether Legionella in some cases is or is not a covered loss. So now we start seeing the exact exclusions where they're literally writing it in. But I guarantee you, as soon as the underwriters get their arms around this and the data, they're going to say, let's start insuring this risk. And if they start to insure the risk, they're going to want to say, that risk is only insured if you can show me your Legionella plan and show me how you're validating it and so forth.
Yeah, just following up on what Tom said, I mean, these insurance exclusions and things like that exist in various policies, they really result, in effect, in turning some of these cases into what I'm going to call enterprise-threatening events. The types of litigation that are going to develop from the case in New York that was described yesterday, even if they have a lot of insurance, it may not be anywhere near enough to satisfy the sorts of claims that are coming in. So I think my point just is that the risk to the property owner, particularly in high-value jurisdictions, New York, for example, where verdicts can be very high, the risks are very substantial to property owners who are not taking the appropriate steps to ensure the safety of the people who are in and out of their buildings. New York has taken a huge step to seeing that happen. But in many other jurisdictions, it is a tough call. But again, the risks are very substantial to property owners, particularly if they're facing an insurance exclusion where they have no coverage to handle and shoulder a lawsuit of the type we've been talking about.
And we'll talk about more of the cons in a moment, but behind all of this, once you've dealt with the litigation, when you've had the track record of testing, you have 3 years worth of Legionella testing results in your archives, what happens when you get ready to sell the building? Do you have a sick building? Do you have an infected building? Are there stigma damages available for people who then buy that building and realize it's got a Legionella problem? Are there disclosure obligations in that context? You have to say, hey, I've got a track record of Legionella coming into the pipes. It gets very scary for people who own and operate these buildings to think about not just the litigation risks, but the collateral damage that can come from that.
That's a good point, and we know these things help because we've seen litigation. This is kind of on the periphery where a large resort hotel in Las Vegas literally got a ruling as a matter of law that punitive damages sought by the plaintiff were not going to happen. That's a big deal. That means the issue of punitive damages doesn't even go to a jury. And that's because they had a program in place and they had taken numerous steps to get rid of the Legionella from the time it happened. The court's ruling was actually that in this case there was no conscious disregard. The exact opposite. They were working on it, albeit not necessarily getting it all, but they had a program in place and they certainly didn't ignore the problem. It brings you to some of the cons because you have a program in place, you're testing your water, maybe your cooling towers come up with a few CFU every other 6 months or so, and your water treatment guys are right on it, and everything is kept in a quote unquote safe arena, and but you got a record. Okay, you got a record, and it proves that there is Legionella in your building, and that Legionella can in fact grow on your premises. And keep in mind that we've talked about the clinical isolates at length yesterday, and when and how infrequently you have them. Think about this: a tourist comes into town, stays at 3 different hotels, goes home within 14 days or so, is diagnosed with full-blown Legionnaire's disease. They come back and they say, and it's diagnosed by urine antigen, so they know it's LP1. They come back and look at the 3 hotels, none of whom mandatory to have tested water, but you're the guy who did. And somewhere in that thing 3 years ago, LP1 in your cooling tower or LP1 in your boiler, who do you think becomes the target?
And in that context, you are forced in the position of explaining to a judge and jury with not the scientific literacy that we have in this room, about the distinctions between LP1 and the many varieties and the pathogenic forms and all the magic that has to happen to get a case of disease. And that, we can fight that battle because we understand it, but the average judge and jury isn't there yet. So it forces you to explain away the bad results or the past results, which is a very difficult position to be in a courtroom.
And we're pretty certain that if it comes down to a situation where there's one targeted building and you're the only one with LP1, and that the closest isolate or diagnostic tool you have is the antigen that says LP1, I think the average judge is going to say, you know what, that's a jury question. And, you know, if you got a dead person in the Bronx in front of a jury of his peers in the Bronx, and there's LP1 in his system and LP1 in your cooling tower, you can understand where these things go. And they don't go very well for the people involved. And it may be that you know, at the science levels that you guys practice, that would be something that would never be a match if the right work would be done. So, I mean, you have to kind of work on that issue of whether you want to do that or not. Source becomes a big issue, and we deal with it all the time in the sporadic cases. 96% we heard yesterday are, you know, unassociated with an outbreak. This was a case in which the plaintiff's lawyer put up a pulmonologist to try to make the source argument. This is actually Susan and mine's case, and we ultimately convinced the judge that this guy did not have the qualifications to do it. Frankly, he literally didn't know what a CFU was. It's in the record. So we had a good field day with him. The judge says, no, you're a good pulmonologist, you can diagnose it, you can treat it, but you can't tell someone in a jury that that's where it came from. And that one, but we had to go all the way to the Court of Appeals in D.C. to get that nailed down. It comes down to the issue in the end of, you know, implementation.
You can have the best plan, the knowledge here that's designed these plans, you know, is significant. What's behind why we're recommending that people take certain steps, you know, it's meaningful. But at the end of the day, these plans are being implemented by people who, generally speaking, who make $8.50 an hour, have a high school diploma, work 9 to 5, have a task list that is full of many other things unrelated to pathogen control. And their view is, quite reasonably, that the pathogen control and microbial control of their premises is not part of their core function. They're operating buildings for safety and comfort and not for public health purposes, as we've talked about yesterday.
Right. I mean, so strategy versus implementation, and it always comes down to, you know, plaintiffs' lawyers love checklists. If they can find a checklist that somebody in your building was supposed to be following, and they can get 10 years worth of records to say that, hey, look, you know, 2013, what happened here and why isn't this filled out? You violated the standard of care. So, I mean, there's always that guy who doesn't get the memo, right?
Nothing else needs to be said there.
Yeah.
In these cases, in juries, what the landlord did, what steps were taken by the property manager, the cleaning, the inspections, are looked at under a microscope. And in some of these cases, when they get to a jury, they literally will go, not day by day, not week by week, but hour by hour, what steps were taken to address the water conditions in the particular system. So it becomes quite an examination.
And so, in wrapping up, I mean, this is an example of an alleged source that we had to deal with, not the source as it turned out to be. Cooling tower alleged to be a source, as it turned out not to be. A very nice, clean, brand-new water heater in a senior living facility that's brand newly constructed turned out to be inoculated. Interesting, up there in the corner, you can see it's written, it says set at 120 degrees. 1970, do-it-yourself thermal water heating preheat system on top of a hotel turned out not to be the source, at least in those pipes, they were all clean. This is when we talk about getting helpful information from our clients. This came from a client who had originally said, I don't have any records about my hot tub maintenance. A couple days later, we get this very conveniently completed document that, you know, that looks like it was done by the same guy in the same pen in the same 5-minute period. You know, sometimes our best work is protecting our clients from themselves. It can get very simple in these situations for a sporadic case. You know, you stayed in, a plaintiff alleges I got Legionnaire's disease, I stayed in your hotel those 2 days, obviously it's you, no testing. You know, we do our homework and find out, look where else you've been doing that. We overlay that incubation period on, all of a sudden it's not so clear anymore. But these are fights we have. The damages are so extensive in these cases that plaintiffs' lawyers are willing to take the flyer. And you got to be real careful because they can strike pay dirt like you've seen in that original slide. Thank you very much.
I think they've given us a fantastic overview of some of the issues here, and I actually want to start with saying two things that I've been thinking about. One is that public health investigations of so-called sporadic cases may actually increase the number of legal cases. The other thing is the issue of litigation comes up when we think about studies. Some of us at Emory have been thinking about a study in long-term care facilities in a state and dividing them where half are actually testing their water and half are not, but they're all getting ASHRAE guidelines and guidance and seeing, does it make a difference in looking at patient outcome? Well, you can see where that might, I mean, these guys would have a heyday with this. So I just think it was important to bring this up, and I really thank all three of you for your coming here today. Please, Brian.
Hi, Brian Shelton from PathCon Laboratories. The testing, not testing debate that you guys go through kind of reminded me, when you were saying it, of, I guess, the debate on vaccines. You know, do I not take the vaccine because I'm worried about getting some adverse effect from it? And when you do that, I guess you leave yourself at risk for the disease. And it would be the same thing, really, with testing for Legionella in the environment. If you deny the operator the feedback to know if his testing is doing what it's supposed to, he won't know if it's growing and can't take additional steps, and now leaves them at risk for Legionnaire's disease outbreak and the punitive damages, et cetera, that go along with that. So,
Yeah, I thought yesterday's talk from the folks from the city was particularly interesting to me when they reported, I didn't know this, that the hotel, the Source, had a brand-new system, cooling tower, well-maintained, the water looked good. All of those factors really suggest that property managers and landlords have to take steps to ensure that their maintenance treatment program really is working. So I thought that was very interesting and a very helpful piece of information yesterday.
Cindy?
Yeah, Cindy Whitney, CDC. I wanted to get some more specifics about ASHRAE 188 and how you think the courts might apply it. That standard was years in the making, went out for public review 5 times. It's issued by one of the largest probably the largest organization of building engineers. But I wasn't quite clear if you were saying it's not quite specific enough, or the courts won't know how to use it, or can you give some details about that?
The court opinions that I referenced looked at ASHRAE Guideline 12, and then the whole universe of publications. Many different documents were put in front of the court for consideration as defining reasonable conduct, and that was ASHRAE Guideline 12 specifically. And when you look at the language in that document, there's a lot of gray areas, as Tom mentioned, with respect to it being advisory in nature and so forth, and nothing that made it mandatory and forceful, like the New York regulations. And so ASHRAE Guideline 12 was specifically evaluated. 188 has not been looked at yet in that setting, and we think that that's in the pipeline at some point in time, and they'll have the same discussion of whether it's sufficiently specific and binding and truly represents consensus. And so that's going to have to be decided by a court.
It was drafted to be code adoptable.
Right.
And so, in that respect, it's being referred to as a standard. Technically, as it sits there, it's not, a standard yet in terms of a court adopting it. When a court says, or a building code, or somebody says this, or legislature says this is now going to be our code, then you're going to see this thing really have the force of law, and it's going to be, the standard of care for any place that says this is now law. And we even had a judge write in an opinion while it was still pending that, hey.
Unless and until.
Unless and until ASHRAE is adopted, I'm not going to give it the full weight of a statutory, but it's common.
And the interesting angle on it as well is people who are commissioning water management plans to follow the ASHRAE guideline are creating their own standard of care for their facility. There's been some litigation about this previously with Guideline 12 before ASHRAE 188, where a hotel their initial position was, we didn't know, we didn't have anything, we didn't have a water management plan, we didn't know anything about Legionella, this isn't on our horizon. They tried that, the head in the sand approach, like, we don't know anything about this. And lo and behold, somebody's, doing a document dig in the general manager's office and finds a binder from, 3 owners past who had a policy manual that mentioned Legionella. And the court said, aha, you've set your own standard of care, and that's what we're going to measure your conduct by. You yourself decided this is what's reasonable for managing your water system, and Legionella control was on the list of concerns. So whether there's going to be the two-pronged approach on ASHRAE 188, whether it is broadly itself a standard of care, and then whether these individual water management plans that are being generated by property owner managers are themselves a standard of care.
Good morning. My name is David Kraus with Geosyntec Consultants. Appreciate the presentation, and one thing that struck me during that is that while the attack rate is assumed to be around 5%, so we're saying that the probability that somebody in the community may be impacted may be 5 in 100. We as public health people since the 70s have actually set levels of for carcinogens at 1 in a million. So it'll be interesting to see where a quote safe level or safe harbor is established, but when we do that, we also drive unintended consequences. The total trihalometane limits are based upon that carcinogenic risk, and it, in my opinion, is driving some of the Legionella issues we're seeing in public water systems. But from a practical standpoint, people overreact. And the things, the chemicals, the treatment systems, the processes that are going to be used in order to achieve either a realistic or an unrealistic standard can sometimes cause more illness, injury, and damage than the thing you were trying to get rid of. The application of chemicals to potable water systems, the application of disinfectants, and cleaning agents, the cleaning process itself for cooling towers brings with it a huge amount of risk of exposure to the employees, the workers, the people walking by, when those things are not done carefully, safely, with proper controls and measures. So I think that's something we also need to consider whenever we're making recommendations. Don't just stop with kill the bug, but how do we make sure that the whole process doesn't take what was a theoretical hazard and turn it into an actual health risk due to exposure to the chemicals. In short, I've seen more injury, illness, and litigation come from botched efforts to remediate things than the agent itself.
Right.
Thank you.
Mike Ostrom. This is a comment and a question. The comment, first of all, starts out with the fact that I absolutely know less about Legionella today than I did 20 years ago, so take everything I have to say with that in mind. But I would suggest to this group in this room, this may be the most important sets of presentations that we hear this entire meeting. And I say that because I've lived for the last 42 years in the area of foodborne disease, epidemiology, and litigation, and watched the evolution there of standards, of practice, and what's happened. And I think some of you may be aware, if you're not, you should be, but over the last 7 to 10 years, we've seen really the emergence of new case law as it relates to listeriosis and listeria, which has many very, very similar principles as we're seeing here, where there's a lot of unknowns, that there really is not a clear-cut answer to what is the acceptable level of listeria in an environment, when does it cause the outbreak, what products might be involved. And I think the question I have for you really relates to the fact that listeria is now driving much of food safety practices and acceptable issues. And the thing that's driving it more than anything is the DOJ has now made this a criminal activity. And I've actually had calls from DOJ lawyers asking about Legionella and criminal activity. And it's one thing if it's civil-related activity, but now if a building manager actually, or a building company, or someone ends up now being criminally charged because of negligence resulting in damages, which I see very similar trends moving from the food side, where I don't know how many are aware, but we have a number of companies in this country right now under a criminal investigation by DOJ for listeria-related food issues, which we'd never heard of before, never heard of before.
Well, we know.
Now, and so I just wanted to ask you where you think this is going, because had I not received these calls from the DOJ lawyers asking more about the similarity between food and Legionella, do you think this is where we're going? And will this be the actual steel beam that will break the camel's back?
It may well be. I mean, you don't only go across the pond to England. People are being charged with manslaughter over there. Politicians that were in charge of, towns. I think it was the borough of Furrow or something over there, where entire city council charged with manslaughter. Furnace, that's the one, yeah, Furnace, yes, charged with manslaughter. And a big push, to bring that, to the U.S. And you're right, the listeria issue may be the first step in seeing that.
And that gets back to the debate of whether we're dealing with a known hazard and people disregard the known hazard because of cost considerations. They don't want to spend the money or do the work to mitigate against these risks in their systems. Is it a known and imminent hazard? And, from a scientific standpoint, I don't know that we're there yet in terms of recognizing when the condition is a known and imminent hazard. So it's an interesting question, and we may be, as we see with New York, you put some teeth on the regulation, you're going to get some response.
But let me just push back a little bit on that, because we don't really have a clue yet when listeria is an imminent hazard.
Mm-hmm.
And yet we're seeing criminal activity, in terms of companies, because they had been one of the companies sampling inside their plant. They found a listeria strain, which may or may not even be related to the outbreak, but they found listeria in their plant. And I couldn't tell you for the life of me today what the safe level of listeria is in ice cream. I couldn't tell you for the life of me what the safe level of listeria is in produce. And yet, so I just say I'm not sure that you have to have a standard today that's accepted to actually see this activity take place.
You saw in the Las Vegas issue where the bridge between, I think, jail and civil penalties is that punitive damage aspect where they look for a conscious disregard. And I think when you get into that, if you start to see conscious disregard like you have in the food industry where they know about it and almost hide it, then you're going to see that's going to be the leaping post. That will probably be the nose under the tent, and from there I think that's where it goes.
And then there's
Okay.
other consequences of, if there's criminal penalties and people begin aggressively treating their water with high levels of chlorine or whatnot, what are the microbial consequences of that? Are we setting up other problems?
Okay, we have a lot of legal considerations here, as you can see. We also have time considerations. So I don't want to see any more people in the line right now. And just make them brief response, and we'll carry on.
Thank you. Hi, I'm Marion Heyman from the Connecticut Department of Public Health. I'm normally not a base, but I have a cold, actually. But I have two brief comments. One, as far as ASHRAE 188 goes, I view it as a good general document for people to do all the time for their water systems. So frankly, I would like them to just change the name and take the word Legionella out of it. And then I'd be happy with it. That's one comment. Oh, the other thing is that ASHRAE documents are routinely adopted into state building and fire codes. We have them in ours. So we will see what Tom suggested here. But the other thing that I wanted to just mention a bit is I think it will be difficult, but we need to sort of switch our brains around when we're talking about the non-outbreak aspect to think of testing and all the things that the AIHA guide discusses as because there are no thresholds. We don't have thresholds. We're not going to have thresholds, I don't believe. But if we just think of this as a tool for building operators to know if what they're doing is working or it's not working, then that sort of changes the conversation a little. And that's what I'd like to see happen. Thank you.
Hey, Jason Kuntz, CDC. So I guess, the bottom line question here. If I'm a building owner and you talk about creating your own standard of care, we often investigate outbreaks where there's no water management plans in place. So if I'm running a large hotel, is it better off for me to put a water management plan in place, whether it's off AHA or ASHRAE, and would the judge look more favorably towards me in, the instance where we would have a case? Because we recognize that you may not be able to prevent all cases of Legionnaire's disease. Am I in a better position if I have that plan in place, or we're not doing anything at all?
I just want to say that given all the media attention that's been drawn to Legionnaire's disease, hotel operators who do not have some water management plan in place are really opening themselves up to substantial exposure. I mean, the first question that operator is going to be asked at his deposition is, have you heard of Legionnaire's disease? That's the very first question. And that owner will very likely say, yes, I have. And then there's going to be about 20 pages of transcripts about what causes it and what steps did you take to ensure that people were not exposed to this, even though there is no 100% solution to this. And it can be very embarrassing for a property owner in that situation. So my recommendation would that you would want a plan in place.
All right, thank you.
Hi, Chris Boyd, New York City Department of Health. I just want to just talk a little bit about what a standard is. And I think it's really important, since we've got a lot of leadership here on this topic. ASHRAE is not a standard. It's a guidance document. It's a very broad, generic, general guidance document. A standard is something that allows you to have a reasonable level of assurance that if implemented, you will be successful. So do I have a reasonable level of assurance that if you follow my code on a cooling tower, that cooling tower will be risk mitigated? Yes. That is true across all the cooling tower configurations. Applying the ASHRAE standard to that same scenario, you would have no idea whether or not you've got a reasonable level of assurance that risk has been mitigated. So I know that the 10-year birthing process for ASHRAE was driven by a whole series of stakeholder interests and concerns. Those interests and concerns aren't necessarily tied to success. They're very much tied to the lawyers who are at the table. So when we look to say, what do people adopt? You adopt my code. You want to figure out how to roll something into your building code or your health code? You change your code citation from mine. Cut and paste. Take about 10 minutes. And ours is driven by the great work of people in Australia and England, Canada, Singapore. We're taking all of this in, and if you look at my code, it's almost structured like his, very similar. So we've combined all of that. So I think when we leave here and we say, what are those steps that you have to do? What's the advocacy we need to do? That's the way to move forward, and that's the direction to encourage other health departments, other building departments to do. And look to these ASHRAE and other guidance documents as broad guidance documents. And that doesn't mean that they're not good, they're not valuable, that we shouldn't look to them for insight. But from a standard perspective, that's not what they are.
Len Mermel, Brown University. Just a quick comment about the pro and con for testing in a real-world situation, which I was asked to represent. I wrote about a 15-page guidance for our hospital for Legionella control. We've been testing, and I've been told by our legal counsel for our healthcare system, we've had over that decade probable, hospital-acquired cases. And we were told that after an attorney came and reviewed our documents, we've been testing since that time, didn't further pursue the case. And we've also, when we've had cases reported to the health department, they've reviewed our policy, seen that we've done testing, and said, you know, keep up the good job. So at least in my experience as a hospital epidemiologist, having a plan, doing the testing, and our cutoffs have changed over time, but the fact that we were following it, at least in terms of the legal aspect, we were, nothing was pursued despite having, you know, possible cases. So I think it was helpful for us.
It absolutely serves as somewhat of a shield. However, in other contexts, in a hospital setting, there's very rigorous implementation and oversight of that process. In other settings, you're not going to have that rigor.
Yeah.
And so it provides you protection, but also creates new problems.
Hi, Clarissa Lucas from CDC, and I was just wondering if you had a comment about the standard of proof, because we're talking a lot about culture results, for instance, and full disclosure, I'm the program coordinator for the ELITE program at CDC, so I'm very well aware of the issues that some labs may have with performing the culture results. So I was wondering, in the CSI age, does PCR trump culture? In New York, for instance, if I had one of those cooling towers that was PCR positive, culture negative, could I still be sued?
I think from our standpoint, with, again, touching on the scientific literacy issue, you have a person who's sick or dead with Legionella-related illness, and you have some Legionella of any sort at any concentration detected by any means in a building, and that goes to a jury, then that's it. The subtleties are lost when you're in that context. It gives us a lot as defense lawyers to work with and talk about, and you may be getting calls from us to have that battle at some point. But if that issue goes in front of a jury, they're not going to worry about those subtleties.
That's why we fight so hard at the judicial level to get a judge to rule as a matter of law, you know, on the science, on the qualifications, on the basis of knowledge, you know, and that's a fight we fight with experts, and it's always a battle of experts. The famous Daubert challenges you might hear about.
Stig Regler, EPA. We have a sort of a two-part aspect when we regulate drinking water. We have what we have to state what the goal is, what the health goal is, and so, for example, for a pathogen, it's generally 0. Legionella, we have as a 0, but then we have to set standards as close to that as is economically and practical feasible to achieve. And so that's where we get into the standard framework, the hazard characterization that you're saying. And so in that context, it becomes very important to define criteria which can be monitored in the context of defining hazard and that are practical to do. So that's, I mean, I did want to set the record straight regarding the DBP regulation. That is not a risk-based standard. We have MCLGs of 0 for carcinogens. We set them as close as possible to what's technically and economically feasible to achieve. And that's based on the best available technology definition, which fits into the hazard characterization. So, well, you'll hear more about the Legionella standard perspective in later presentations.
Yeah, we have gone over time, but we have certainly set the stage for the next 2 sessions. And I will turn it over to Kim Musser and Shantini Gamage now. Let's thank the attorney very much for being here.